in the case of Central Bureau of Investigation versus R.R. Kishore. The Supreme Court has recently observed that when a law has been declared unconstitutional because it violates Part 3 of the Constitution, that is, any rights that have been enshrined under Part 3 of the Constitution, such law will be an unenforceable right from the date of its commencement. Now, before proceeding any further in the case, let's discuss or let's have a look at what actually has been laid down under Article 13 of the Constitution of India. Article 13, Clause 1 of the Constitution of India deals with the pre-constitution laws. As the name suggests, pre-constitutional laws are the laws that were in force in India before the commencement of the Constitution of India. Now, any such laws which were enforced before the Constitution of India came into force and are still there have become inconsistent with Part 3 of the Constitution, that is, it violates any fundamental rights that have been enshrined in Part 3 of the Constitution of India, will, to extent of such contradiction, be void. Article 13, Clause 2 deals with post-constitutional law. The Constitution in this regard says that the state shall not make any such laws that abridges or takes away the rights that have been enshrined under Part 3 of the Constitution of India, and if any such law is made, such law would be void to the extent of the contradiction such law does to the fundamental right. Let's have a look at the facts of the case. So what happened in the present case was that an arrest was made under Delhi Police Special Establishment Act 1946 without prior sanction, promoting legal challenge on ground of violation of Section 6A of the Act. Now, what the particular section mandates was prior permission of the central government before investigating an officer of rank of Joint Secretary and above in corruption cases. The matter went before the Delhi High Court, and the Delhi High Court directed the Central Bureau of Investigation to re-investigate the case after seeking approval from the government. Aggrieved by the decision, the CBI challenged the decision of the Delhi High Court before the Supreme Court in the year 2007. Now, in an interesting turn of events, Section 6A was declared unconstitutional by the Supreme Court in Subramanian Swamy judgment delivered in the year 2014. Now, the issue before Supreme Court of India is whether the ruling that has been delivered by it in the Subramanian Swamy judgment in 2014 will apply to the pending cases or not. The Supreme Court, while considering that whether a person can be deprived of the immunity that has been conferred by the statute upon such person owing to retrospective operation of its 2014 judgment, which had struck down the immunity granting provision. To consider this, the Supreme Court had to delve into the meaning of the word void and the difference between Clause 1 and 2 of Article 13, which deals with pre- and post-constitutional law. The Supreme Court reiterated that pre-constitutional law that have been given under Article 13, Clause 1 would continue to subsist except for the part that is in contravention to Part 3 of the Constitution of India. And with regard to post-constitution laws, the laws that have been enshrined after the enactment of the Constitution would be nullity from its inception if they are in contravention with Part 3 of the Constitution. The verdict was delivered by Constitution Bench of the Supreme Court. The court had already reserved its judgment in November last year after hearing the arguments over the pivotal issue that whether its judgment Subramanian Swamy versus Union of India in the year 2014, which had struck down Section 6A of the Delhi Police Special Establishment Act 1946, which mandated that central government's permission would be required to investigate certain government officials, will apply to the pending cases. The Supreme Court in this case has conclusively held that once a law has been declared unconstitutional, being violative of Part 3 of the Constitution, it will be void ab initio, non-est, and unenforceable in the light of Article 13, Clause 2 and interpretation by authoritative pronouncements. Thus, the declaration made by the Supreme Court in the Subramaniam Swamy judgment in the year 2014 will have retrospective operation, and Section 6A of the Delhi Police Special Establishment Act 1946 will be declared to be not in force from the date of its insertion, that is September 11, 2003.